Want to find out what's going on at the appellate division? Stay tuned for this legal scoop. This month we've got Foster v. Monadnock Construction, which is a case from the Third Department from February 2026. And the gist of it is that it's an accepted facial injury claim where the claimant then in 2023, 3 years after the date of accident, raised TBI, post-concussion syndrome, headaches, other conditions to go along with the accepted facial injury claim. So yeah, getting into the facts again, it's an accepted 2020 facial injury claim from a ladder falling and hitting the claimant in the face. Then in 2023, the claimant raised, again, TBI, post-concussion syndrome, cognitive deficits, and headaches, alleging that they were causally linked to the 2020 date of accident. And the carrier raised Section 28, which is the statute of limitations, saying that it's been over 2 years, you can't raise these injuries. So what did the Third Department end up doing here? Well, they affirmed the board's decision to say that the claim for additional conditions was not untimely under Section 28. And the reason being is they said there was timely notice, the claim was accepted for a facial injury, and there were medical records from November of 2020 documenting complaints of lightheadedness and basically that the claimant was under observation at the hospital and that he underwent CT scans to check for the facial injuries. So with all that combined, they said that it's not just the claim form that satisfies the Section 28 requirement for timely filing. It can be satisfied in other ways. They also said that, well, these are consequential conditions which are not time barred by Section 28. How do we feel about this one? Kind of so-so. There is case law to support Section 28 barring additional conditions being raised after 2 years. Here, my problem with this case is that the Third Department doesn't really very clearly discuss whether it was raised as a direct injury versus a consequential injury, or condition in this case. So, for example, it seems like it's just sort of assumed that because it was established for a facial injury that the TBI, the post-concussion syndrome, the cognitive deficits are all consequential to the facial injury. But really, I mean, a TBI would be something that would be a direct injury. It'd be something that would be raised early on, and then potentially post-concussion syndrome would be consequential. So in a lot of ways, this looks like one of those examples of the Third Department kind of yada-yadaing its way through its decision in a way that leaves a little bit to be desired, because I think the carrier was really onto something here by raising Section 28 3 years after the date of accident. So what does this mean for your cases? I would say business as usual. We still feel that this leaves it open to raise Section 28 for claims that are brought up over 2 years after the date of accident. Just because the facts of this case with facial injury, post-concussion syndrome, TBI, things like that, it's understandable that they came to the conclusion that it was consequential. But if you get a claim where additional sites or conditions are being raised 2 years after the date of accident, you still should consider Section 28 as an option for getting those sites or conditions denied.